It's case D446900. Feindel. Council appearance for the record.
Good afternoon. Shelley Lubritz, 5410, on behalf of Tim Feindel, who's present.
Shannon Weinstein, Your Honor, file number 5551 with Amanda Feindel, who's also present.
All right, we were last here, looks like on December 7th, we entered a parenting agreement, and then looks like council were to confer on the financial issues. So.
Right. If I may,
Okay.
I did send a couple of days ago, that was my fault, Mr. Feindel had sent it to me earlier, a copy of his check stub for the independent contracting work that he had been doing. The
Okay.
court had told us they wanted to actually confirm, have a copy of the paycheck stub so they could do whatever they wanted to do. We provided that. I can tell you that Mr. Feindel is submitting another invoice on Friday for roughly how much?
$25 an hour, 25 hours a week. It's been what it is since it started.
So we will have that, and we can certainly present that if they want to see two pay periods or two paycheck stubs in a row. He's not paid on any regular basis in that he's an independent contractor. So he basically does his work, and then he submits an invoice, and then they pay him. So it's not like we can say on the 1st and the 15th he's going to get paycheck stubs. But certainly if they want to see the next 2 or 3, we have no objection to that. In light of that, my client has already said, you can sit down, Tim. My client has already indicated that he's not looking for separate maintenance payments from his wife. He's able now to support himself. It's his hope that he will go full-time. If he's able to go full-time and they need him, he'll be roughly at the same income that mom would be. Our proposal is that, I know under Fernandez, we're not supposed to quote waive child support, but because we expect that dad's going to be up to mom's level, hopefully in the foreseeable future, maybe this year, my thought is we could just simply find a deviating factor in 125B.080 and just waive child support, and each party would, they still split medical insurance issues under 30/30, but waive any payment of a check one to the other. The other issue that we needed to address, Judge, and I would ask, we have a problem with ourfamilywizard.com. We were kind of blindsided the last time we were here in that the parties had already agreed in mediation not to use ourwizard.com, and because mom had wanted to do that when they were in mediation, without telling me that they were going to raise that issue at the last hearing so I could be smart on this website, because quite honestly I'd never heard of it, much less used it. The court said as long as mom pays the fees associated with it, it doesn't hurt anything, the court would have access to communications between the parties, so go ahead and do it. My client, who has been certified in family court as an expert in computer forensics, brought to my attention the waivers that are required. When you go onto the website, apparently there's this whole list of things that you are agreeing to, and it says that if you don't agree to everything in these terms and conditions, you are not allowed to use the site. Don't click the I agree button. When that was brought to my attention, I sent an email to Ms. Cohen saying, here's the problem, this is why we haven't signed up for it. We need to talk about it so that I can tell you specifically what needs to be waived, because mom would have to sign some releases in order to allow dad to utilize this site under the terms and agreements. One of the things is that he has a relationship and a connection with, and this is where I may need help, Atomic Data provides the IT infrastructure for ourfamilywizard.com. Mr. Feindel has worked and continues to work and has a connection with Atomic Data. So we wanted them to acknowledge that we've admitted that he has this connection and either waive any potential conflict or say we're not going to use it anymore, because he conceivably, his connection with Atomic Data could cause a conflict for them using the same, the hosting basically computer that ourfamilywizard.com runs on. And because they've made allegations of him doing certain things with technology and computers that are, quote, bad, we don't want to have them come and make these other new allegations. The other thing is that it says, for example, on subsection F, confidential personal information. You are at all times during the term of this agreement and thereafter solely responsible for obtaining and maintaining all legally necessary consents, permissions required as or advisable to disclose, process, retrieve, transmit, and view the confidential information you transmit, store, or receive in connections with the site. We can't claim that we have consents and permissions if we don't have something from Ms. Feindel that says that you have my consent and my permission. There are third parties that will have access to all of this information. The court would have access to the information in some sort of an ex parte manner. My client, if he wanted to get those documents, would pay fees of close to $200.
You have to
In
pay
order
to subpoena them.
To subpoena the documents, that the emails that are transmitted on this website, so that it's admissible and not just like a screenshot. It's going to cost roughly $200 each time you want to gather. It's 18 cents a page. There's an $80 minimum or base, and then there's a $150 fee.
And then a tack-on fee for whatever they deem as research costs.
Right. So
Again, with an email, I can just print it.
what I really wanted to get across to the court last time, and it still remains our position, these are the email files for this case only. So there's no way you can tell me that they can't communicate via email and that email doesn't work. Okay, I have 3 folders of emails, more than, a ream of paper where they have been communicating via email throughout these proceedings, and there hasn't been a problem with it. And so I would ask the court to consider that number one, they already agreed in mediation at FMC not to use our wizard.com. Then, without telling me they were going to bring it to you, brought it to your attention when we signed the parenting plan, despite the fact that my client gave up certain things in order to not have our wizard.com. For example, he didn't like the 21-day visitation in the summer. He wanted 14 days. As a concession to not use our wizard.com, he gave in on that 21 days. So
It's ridiculous. First of all, I can't get into it, even if I could, but that would be ridiculous. But
at a minimum, Judge, what I'm telling you is that we didn't have notice. I didn't have this information at the time. Now that I have it and I've given it to you, there are 4 places where we would need Amanda to specifically consent to certain things so that my client can legally use the site. He needs some certain indemnifications because using the site can expose him to litigation and being sued by clients of his. And I can let him explain that to you a lot better than I can because I certainly don't understand it. Would you indulge him 30 seconds?
no, I'm not going to. It's
Okay. So we're asking that wizard.com not be used. There's no reason for it.
Then, I'll hear from Mr. Winsett, but
The only thing that we would do is designate, this is the only email that you can send to me on, this is the only email that I'll send to you on, and we'd be done with it. I don't think we need this third-party access, which is going to cause a host of problems, and it was specifically negotiated away. They're coming to you in bad faith after...
I don't know why someone would negotiate child custody over the use of a computer program.
I didn't say that we negotiated child custody over it. Mom brought it...
Time with their children. Time with their children. You said 4 win a week.
The woman that taught my client's class for the cooperative parenting UNLV course said she thinks it's a bad thing to use. And she's an expert who's teaching it. It was brought up in her class. She says it's not appropriate, it's not appropriate.
The point is, it's ludicrous that he would forego a week of time with his children not to use a particular program. Sit down, sir. I'm not talking with you.
No, it was the vacation span, Judge.
Okay,
He
that's
still
still a
had the
week.
same amount of time. She would get 21 days and he gets 21 days versus she gets 14 days and he gets 14 days.
I really don't get it, but do you have any problem signing the waivers and the indemnifications ridiculousness? Sign whatever waivers.
Judge, I don't even know where to start. The waivers are in the. She accepts the terms of the agreement. When you click on I agree, she's accepting everything that he would accept to.
Right.
She would waive a conflict of interest, absolutely. But I don't think it's necessary.
I don't think it is.
It's just a reason not to do it. There's a stack of emails. Obviously, we wouldn't be. If that was working, we wouldn't be here requesting our.
I agree. So if you want to craft some sort of waiver, I'm not getting any sort of indemnification.
How is it not working?
Craft the waiver. It's a program that many courts in this building and throughout the country use.
Right.
And if she's willing, apparently the
And without motion, on an oral request,
I can do-
over my client's objection,
Right.
without me having any time to review it so I could get smart and argue about it.
then do it, Ms. Lubitz. It's a very common request for third-party monitoring.
17 years, it's the first time it's come up for me.
I'm shocked because we've been using it for at least 2 years, and almost every other department upstairs, as far as I know.
I can only tell you what my experience is, and I can show you that I have these kinds of files for every single case because I print them out. The mom's gripe was he was using an email address I didn't want him to use.
Okay. If you want to craft the waiver you're requesting in addition to what they've already click on, then craft it. As far as any indemnification, ridiculous. I'm not getting into
Will
that.
mom pay for the subpoena cost if dad needs to get copies of the documents from
No,
the
we'll
service?
print them out. That's the beauty of having this. I'm not going to get into any of that. That's why we can access it as third party, so we don't need to get into any of those costs.
But do you understand that the way that he prints it out is not legally sufficient for admissibility because it doesn't include headers and all the language that we don't
Lewis, I'm not. Listen, we're talking about stuff that might occur in the future, and that's the beauty of having this sort of Our Family Wizard program. Then you
If
can.
your instruction is for me to draft the waiver and the release, I will do that.
Okay, if that, I don't think you need to, but if that's what you need to make your client feel better, so he can sign up, which is technically the existing court order, do what you need to do.
Yes,
Okay.
very well.
All right.
And we'll have an immediate signing and.
As far as the waiver portion of Fernandez, I disagree with you. If they're waiving it right now, Fernandez is just that they can't permanently waive it indefinitely, and either one of them can come back in the future for any modification.
Your Honor, I
just
think
wanted
we're
to
this
set
close to
child
settling the
support
case.
Okay.
All that we wanted last time was a verification
Ask me
of,
what you want.
of his employment and his income, and we received a check in the amount of $1,000 yesterday. That's all we want. We verify the income. That's all we're asking for. If the court sets a trial date,
I'm hesitant. I'm not going to set a trial date if you think that one more. Do you believe that in the end he earned somewhat similar to your client? I mean,
that's what we're asking. That's all we're asking for is to verify his income, Your Honor. And so, otherwise, I think once we verify that, we can in good faith finalize the case. The reason I'm requesting a trial date, Your Honor, is trial dates tend to settle cases. They keep them from languishing. And so if the court sets a trial date, it'll give incentive to get the decree on file.
Here's the thing. Once I set a trial date, someone's paying attorney's fees.
Thank you.
And if you get what they're saying, then you're probably paying their attorney's fees from that day forward. A status check date, probably not. Trial date, yes. So Again, I can also order that he discloses taxes once he files them. I can order that both of them continue to exchange their tax returns every year once they file them to make sure that there's not going to be the 20%.
Your Honor, if you just have him disclose all of the checks that he's receiving, the identity of the company, and if we feel that that's not enough, that we can subpoena his company for his paychecks.
The last time we were here, they said all they wanted was a paycheck stub, and I had wanted to redact or whatever, and you said no. We gave them an unredacted paycheck stub.
It's all going to come down to what he's filing as far as taxes anyway. I'm not going to just give carte blanche into.
Fair enough. Your
But
Honor.
recognizing that she writes her own W-2s, so but
Okay.
that's for her company that she does.
Which
But
is
that's
not true.
fine. But we would ask them that child
She
support is
wa-
set today. They have verification of what he earns. She quadruples what he earns right now.
Again, I guess it's the risk.
It is, Your Honor. If the court would order him to what we received is $1,000 check. We don't know the terms of his employment. That's all that we're trying to determine.
Again, I can order that he give you his tax returns when he files them, because under the statute, that's what we all fall back upon anyway. When there's a, but you want that before we make a decision, or you want to go ahead and waive? Because again, it's a risk you take. Because if his tax return does that, then your client may be paying.
If the court would order him to disclose his tax return, then that will give her sufficient comfort knowing that we know what his income is.
And Mom will do the same.
Yeah, we can order that every year hereafter as well.
All they have to do is ask me that, and I agree to that every single time and twice on Sunday when we have joint physical custody. look at her tax return and show the difference and show she.
Okay, we'll go ahead and order that the parties are to exchange their full tax return to the other party by the 30th of April every year hereafter.
No, Your Honor. When I said, Your Honor, we're fine, I meant to say that we're fine. We don't need any further disclosures.
We'd like it, Judge.
No, I'm saying in the future, though.
Yeah.
Are you saying how are you ever going to know?
We'd like it because if it's all based on joint physical custody,
Right.
if Mom's income goes up and Dad's doesn't, then we'd be entitled to seek an increase. So I
Either
think
party
we
is
should
entitled for the
still there.
20% because we'll just assume. So right now we're going under the presumption that they have an even income, which is obviously going to be the duration for this year. But hereafter, for the joint physical custody, if you exchange the tax returns, then you can legitimately see if someone's had the 20% increase, decrease, whatever that would set them up for a
Yeah,
modification.
respectfully, how can we do that? As you recall, my client's been unemployed since before the marriage, and so he
Well,
just
again,
got
that's-
a job, and they are nowhere near. She says on her financial disclosure she earns $54,000 a year. My client works part-time at $25 an hour. That gets him only to half that, so I don't know how you can just draw a presumption. She complained every time we've been here that he earns no money.
You're the one coming in asking for the waiver. You're the one calling.
They're totally different.
Right.
I didn't know we're exchanging one for the other. That's like saying exchanging 21 for 14 days for ourwizard.com. Respectfully, they're separate issues. You can't say respectfully that I want them to sign a waiver for ourfamilywizard.com, so therefore he's gonna not be able to get child support this year.
What does our family wizard and signing the waiver have anything? You've now brought two different things, and you've brought he gave up a week of vacation for it.
No, there was more than that, but that's fine.
Regardless,
I didn't
what does
understand
our
what you
family
just
wizard
said.
have anything to do in negotiations with the payment of child support?
Because I thought you just said that he came in asking for a waiver, so therefore we're going to just assume he's earning the same.
No. I thought you said you were the one who said under Fernandez we would like it just to be.
That was if we got everything resolved and got this case resolved.
Do we not have what don't we have resolved?
We don't have any asset and debt distribution resolved. We don't have an understanding as to whether or not it's divorce or separate maintenance because we filed separate maintenance. Mom has indicated she wants a divorce. We haven't resolved child support. Nothing's been resolved except for custody. So if we're going to come in and we have sent proposals before. We could take right now, have everybody keep what they've got, waive child support, and make this all go away.
That's what I thought we just did. Am I wrong?
No, because now we are stuck with ourwizard.com. My client has a huge problem with
Ms. Lubert's
familywizard.com that the court does not understand.
That I don't understand?
Yeah.
I think I understand it sufficiently enough to.
I think an expert witness would take for me to fully understand it and for the court to fully understand it. I'm not trying to denigrate the court in any way. I don't fully understand it, which is why being caught off guard when they blindsided us last time we were here and brought it up after it had already been negotiated away.
We have what's ironic about this is we now have a video record about the ludicrousness of it, about a waiver of using a court program that people use throughout the country as some sort of financial leverage to get the entire case done.
And respectfully, I think
Ludicrous.
we also have video record. I would say the same thing about what the court's statement
I don't get it.
has been and the lack of the court's understanding about the problem.
For the record, Your Honor, Ms. Lubertz continues to refer to things that took place in confidential mediation regarding our parent wizard, which was not agreed to, which was not part of the settlement.
Exactly, it wasn't agreed to.
But she keeps saying that she's been blindsided by a reasonable request that this court already ordered.
It was asked for and it was court ordered. So that's.
So we'll sign our waiver. I mean, we'll prepare a release and
Right.
waiver.
So what else is the issue at this
I'd like
point?
to have child support set. I'm not waiving child support if every issue is not resolved. And obviously every issue is not resolved by stipulation because you've just now, over my objection, confirmed your order that they're going to use our familywizard.com. So I would like child support to be set based upon the financial condition of the parties. And I don't think that there's any basis for the court to order a waiver.
It's not before the court.
I'm not ordering the waiver. You're the one walking in asking for it. And I
Only
can
if we
also do
resolve
on his
everything,
earning
Judge.
capacity, it's not actually what he's earning, so.
And his earning
Set for trial,
capacity
set
has
for
been
trial.
unemployed for 2 years.
Okay.
I would like to. Does the court want to set this for another status check to give
I don't know. Do you want to go talk out right now? Because if I set a trial, I'm setting a trial.
Tim?
I think.
Question?
I really don't know what assets and debts have accumulated in this short term of.
Yeah, okay, you know what, we may be able to settle it right now. Shane, can I have some minutes with you?